Good afternoon, folks. I'm Luke Swetland with the Santa Barbara Museum of Natural History, and I'm delighted to welcome you all to this, our first Lunch and Learn webinar of 2025, presented by the museum's Plan Giving Advisory Council. You know, for over 100 years, the museum has provided education to this community in a wide variety of forms, often at no cost. And that's the case today with today's Lunch and Learn, which is going to focus on the 10 biggest mistakes and misconceptions in estate planning. You know, supporting a good cause through an estate gift is a great way to marry your legacy with an organization, and it helps that organization continue to do the good work that it does. So I hope you'll consider a great charity in your estate plan, and I hope you'll consider the museum. Before we get started, just want to do a little infomercial about what's happening at the museum and the Sea Center. We recently opened a new basket exhibit in our Chumash gallery, curated by curator emeritus Jan Tinbrook. She worked with a variety of contemporary Chumash weavers. So this is a great show about Chumash baskets, both historic and contemporary. Our exhibit, Fashion Fatale, explores the human obsession with feathers, and that's on view in our courtyard gallery. In our Maximus gallery, we have amazing animal portraits in our exhibit, Big Cats and Wild Dogs. If you want to take a look at the universe, come visit one of our planetarium shows. If you want to take a look down in the channel, go to the Sea Center and check out our wet deck. There's just so much to do at both the museum and the Sea Center. Just check out our website, sbnature.org, and you'll get whatever is happening on any given day. And now let's get started with the program. And so I'm going to turn this over to my colleague, Andrea McFarling. Andrea?
Good afternoon. Hi, I'm Andrea McFarling, the Santa Barbara Museum of Natural History's Philanthropy Officer of Legacy Giving. We're happy to share with you this free webinar with helpful information on how to avoid the top 10 mistakes and misconceptions in estate planning. Today's webinar is presented by our good friend Brett Piersma. Time has been allocated at the end for questions. Please place your questions in the chat, which you should see at the bottom of your screen. If you should have any technical difficulties during today's program, please email Robert Shutt. His email is also in the chat. Feel free to reach out to me if you have any planned giving questions or need more information. I am here to help you leave your legacy, and hopefully you will keep the museum in mind in your planning. Now I'd like to introduce our speaker, Brett Piersma. Brett transitioned into the practice of law from a high school teaching career. He attended the College of William and Mary School of Law in Virginia for his degree in law, and he is now a partner and the chairperson of the estate planning department at the Santa Barbara law firm of Mullen Henzell. His practice is concentrated on advising clients on all aspects of planning their estate, including both revocable and irrevocable trusts and gift and estate taxation issues. Brett is also very active in the community, teaching constitutional law as an adjunct professor at Westmont College and community property at the Santa Barbara Ventura Colleges of Law. Brett is a member of the museum's Plan Giving Advisory Council, and we're so thankful for all his advice and guidance. Brett, thank you for speaking with us today. I turn it over to you.
Thanks, Andrea. It's a pleasure to be with you all today on this wonderful, warm, sunny day. Hopefully we have some good rain this week and you all stay safe. Well, talking about estate planning and your legacy that you want to leave in the context of how you may assist the museum and your family is a great thing to do. And it's a good thing to think about early before it's too late. And so this presentation should hit really the top 10 things that I've seen in my practice. There are certainly lots of other things that can go wrong. And if there's any questions that you have, my contact information is on the screen. Or if you're a practitioner in the area and you think I maybe missed one or two, certainly feel free to send me an email because we're trying to just hit the top 10 and there are lots. But these are the big ones. So we'll start with what I like to think of as what would the perfect world look like in terms of estate planning? Not the perfect world, big picture, but the perfect world in your estate plan. Well, in the perfect world, your estate plan would be written, the documents would be complete, they would be accurate, they would reflect really all of your wishes and all of your desires. And not only all of that, but your plan would then be carried out uh, upon your death in that way. There would be no ambiguities, there would be no errors, there would be no delays, there would be nothing that was missed in the drafting or included in the drafting that turned out to be incorrect. And so those two things are the great desirable deliverables when I'm working with clients, when clients are sharing their information with me, or when you are reflecting on what you want your legacy to be. You want to make sure that you have documents in place and that they are correct and true and up to date, and that there have been no changes, and that when the time comes to carry them out, people can do it. There's not stuff that just gets missed or confusion. So what is it that gets in the way of that? There are many, many, many mistakes and misconceptions. And I put both mistakes and misconceptions because sometimes there are just plain mistakes that need to be caught or reviewed ahead of time. Other times there are misconceptions that lead people to make mistakes where they thought it was correct, but they had a misconception. They didn't understand the law or they didn't understand the rules. And so those things, those mistakes and misconceptions interfere with us accomplishing both number 1 and 2, the first 2 bullet points on the slide. And so today we're going to go through just the top 10 mistakes and misconceptions. Well, mistake and misconception number 1, I was out at a dinner recently and I said, I'm doing this presentation, and they said, let me guess, your first mistake and misconception is failure to have a written estate plan. And I said, bingo, bango, you got it. That's correct. Not having a written estate plan is the first mistake and misconception. And sometimes it's a mistake. I have clients who call me and they're at the end of their life and they have never done an estate plan just because they didn't get around to it. And that's unfortunate. Sometimes we can get one done in time and oftentimes we cannot. And so failure to have a written estate plan is the big mistake, misconception. And sometimes it's based on a variety of reasons. Sometimes it's just life gets too busy, or sometimes it's based on false beliefs. False beliefs like, oh, I can just tell my family verbally what I want to happen and they'll do it. I can just have a conversation with everybody, or maybe write it down in a notepad or a journal or something, or a document that I have on my computer and I sign it, and then just give it to them. Well, that's a mistake and a misconception. Sometimes it's based on the understanding or thought that, well, all of my assets will just pass by beneficiary designation automatically to my heirs. And if that happens, then they'll get it without there being any written estate plan. Well, that's not necessarily true. So mistake, and well, let me go back to this. The failure to have the written estate plan could be from these 2 reasons, or you had a written estate plan, but then it was lost or destroyed, or it was revoked and never replaced. Sometimes that happens during divorce. And so not having an estate plan is the biggest mistake. Now, moving on to the next mistake and misconception is that, well, an estate plan really just, you need to have a will. And certainly many people in the audience today have heard of trusts. They certainly have heard of wills, but oftentimes clients wonder what the difference is. They think that they're the same thing, or that they're one document that includes a trust and a will, or a variety of other misconceptions. But sometimes clients think that really they're just, all I need is a will. But there are fundamental differences between trusts and wills. Some people, very few, I will say, just need a will. And those are people who have very few assets. They have assets that pass by beneficiary designation, and maybe they just need to express a few wishes in a basic will. I've had clients like that, not many, because the threshold is very low in terms of the dollar amount and the kinds of assets that you can pass without having a trust. So most clients, most individuals these days will need a trust as well. And so you'd need both a trust and a will. Now, the last point on this slide is a really important one that many people don't understand. People think that if I have a will, and I don't have a trust, but I at least have a will, then I won't have a probate. I can avoid a probate altogether by having a will. That's not the case. Wills need to be probated, and that probate proceeding takes time. It costs money. It creates delay. It creates publicity in the sense that it's in the courthouse and there are hearings that are open to the public and there are publications made in the newspaper. And sometimes that's, families don't want that. They don't want their entire, all the assets and all of the hearings to be publicized. So a probate is something to be avoided usually. Sometimes we have probates on purpose because of various reasons, but for the most part, most families don't want to have to go through a probate. So just know that a will does not avoid that. A trust, if it's properly funded, will avoid a probate if there are no other reasons to have the probate. Okay, we're moving along. Mistake and misconception number 3. You can just do it yourself, or thinking that you can do it yourself as cheaply as possible. Times are tough for a lot of people, and it's very reasonable to try to find the cheapest way or the most inexpensive way, or maybe call it the most efficient way to have an estate plan that doesn't cost you an arm and a leg. An estate plan shouldn't cost you an arm and a leg, depending on how complicated it is. Some estate plans are tremendously complicated, and they do take many, many, many more hours than others. And so trying to do it cheaply is not a problem, only when it results in misconceptions or mistakes because of how cheap it was done. So there are lots of alternatives to hiring an attorney. And these are not, I'm not listing these because they're bad necessarily. I'm listing them because they are oftentimes, they lead to mistakes that could have been avoided if the client had just gone for the upgrade. In other words, talking to an actual attorney. For example, the museum has a wonderful will planner at sbnaturelegacy.org. So it's not wrong to say, well, I don't need a will, a trust. I'm going to have just a basic will, and I'm going to go online and do it at this website. As long as that's appropriate for you, and that's going to depend on lots of variables. If that's an appropriate estate plan for you, then there's no problem doing that. But it's only a problem if it turns out that you don't need just a will, you need a trust. So now this online thing and this tool that you've used to get a will turns out to actually not solve many problems and can potentially cause more problems. Another website that I see oftentimes is LegalZoom, legalzoom.com. It's fine. LegalZoom documents can be very useful and they can be appropriate. I've seen many of them that are not. I've seen many of them that miss things, or the law is not quite right, or the application of the law to the client's particular needs is not quite right. And so in that circumstance, now we have documents that sometimes it would have been better to not even have documents. It would have been better to have a probate of a non-will, non-trust situation because of what are called the default rules, which I'll get to later. There's a service called We the People. Many of you may have heard of it, a local office here in town, wethepeople.com. And their saying is, no lawyers save money. And it's absolutely true. By not having lawyers involved, it's much cheaper. We the People documents, I've got many, many examples in my memory of clients who came to me with We the People documents. And usually they come to me when they know that the document is not appropriate any longer, and we update it and everything's fine. I've had only 1 or 2 where a person died and the We the People estate plan ended up becoming the permanent estate plan, and it was not good. It caused more problems than it would have avoided if we had just not had an estate plan altogether. So using a service like We the People can be appropriate, but it can also lead to mistakes. Finding forms online. I have clients who email me and say, oh, here's my will. And I open it up and it looks like they found a thing online, or they went to the library and photocopied a blank will and then filled in names and things like that. That could work, could also be really problematic. So it's just another tool out there that people like to use. Sometimes clients or individuals think they can take someone else's estate plan and simply change names, change beneficiaries and dates, and put their own trust name and all of that, and call it their own estate plan. Just print it, white things out, put new names on it, and call it theirs. A big mistake, because every estate plan really needs to be tailored to your situation and not to somebody else's situation that you then just cut and paste. Lastly, freeform drafting your own estate plan after conducting some research, online, going online and saying, oh, well, I read about wills and trusts, and so I've written my own trust. there is a very slim chance that doing your own estate plan documents is going to be sufficient and that they're going to accurately capture what needs to be captured and the rules that need to be spelled out for how to administer your estate. So that's a big mistake and misconception. Okay, number 4, failing to have your team coordinate together. And I put team in quotations because your team can consist of whomever you want to have on your team. I'm going to list and describe sort of who I see typically on your estate planning team for my clients. Should typically be your accountant. You want to have your CPA involved because they are going to be the ones who know your income tax bracket. They're going to know the value of your estates. They're going to know whether your entities, how they're formed and the K-1s that are coming out to you. And they're going to really help the other members of your team, including your estate planning attorney, design a plan that is appropriate. So having your accountant as part of the team and help to coordinate with your others is very useful, including your financial planner. Your financial planner or advisor is the one who knows what investments you have, what stocks and bonds, whether there's basis issues, whether there are, transfer restrictions. So having them on the team is very helpful too. And lastly, of course, with your attorney, the 3 of us work together in addition to somebody else you might want, like the senior member of your family. Maybe there's a matriarch or a patriarch, or maybe there's a person at the family office, or maybe there's the head of the business that you started many, many years ago with somebody else or with a team. So having some of those folks join the team, maybe temporarily or to be involved in the planning, can be very useful to help us avoid mistakes. You can think of I can certainly think of it, maybe you can imagine some examples too, where if you had your accountant and your attorney, or maybe you just had your attorney work with you on the plan, but the attorney was never informed of certain restrictions that are in your closely held business, or certain assets that you had invested in. Maybe it's cryptocurrency, or maybe it's something that your financial planner had gotten you invested in, like limited partnerships. If your attorney doesn't know about those, then your attorney could then draft a plan that doesn't adequately address them or handle how the transfers, where they're going to go, which can then create issues many years later. Some of the issues that we see many years later are things like, well, upon the first death, the split of the assets between the spouses and the 2 trusts that get funded, that split then resulted in some assets being put in trusts that later on, in other words, after the second death, now don't get a step up in basis that creates lots of built-in gain that could have been avoided. So lots of nuance there, but the point is having your attorney speak to the other people that are part of your team will help to avoid mistakes. Okay, moving on to number 5. Oftentimes we prepare estate plans, we spend lots of time, and we drill down into the details, and I understand the family dynamics, what the situations are, and we craft a really wonderful product, and the client signs it. And following that meeting, we, the attorneys, can often, we can fund the trust with some of the assets. For example, your real estate, we can prepare the deed to transfer your house into the trust. But we can't fund the trust with all of your other assets, such as your bank accounts, your investments. We can do entities like limited partnerships and LLCs, but not everything. So a big mistake is to create this great trust, but then fail to fund it. Creating your trust is not enough. Even going through all the process of creating the trust, designing all the language, and even writing on the trust instrument all the assets that you want to be in the trust, that's also not sufficient. Many clients come to me and say, well, here's my estate plan, and so-and-so died, and we look at the document and it says, oh, it looks here like you intended for this property down in LA to be in your trust. And I'm like, yeah, it's there. It's written on the trust document. But we go and we look at the title history of the property, and it was never transferred into the trust. So now we have a disparity. Clearly, the client wanted the asset in the trust, but the asset was never actually retitled into the trust. So it's not enough just to have a trust and to list assets that are in it. You have to actually put those assets in it by changing the title. Your assets must be transferred to it by title or by assignment, updating a deed, doing what's called a trust transfer deed or a quitclaim deed, going to your bank or your brokerage company and putting the title of your brokerage account into the trust. So that's how you fund a trust. If you don't fully fund the trust, or if you partially fund it, you can have a probate, which of course you've spent all this time and money to try to create an estate plan that avoids the publicity and the cost and expense and delay of a probate. And now here we are in probate court. So if we have a probate, even though we had a trust that was partially funded, we have to go through that process too. So now you have a trust administration and a probate, and we've done them. There are workarounds. I hesitate to even put these up on the screen because I don't want clients or people to get the impression that, oh, don't have to worry about it. We can always fix it at the back end. But we attorneys are good at fixing problems that come to us. And one of those is a not fully funded trust. Two workarounds that I've used in the past are what are called 850 petitions under a case called Hegstead, the estate of Halvard Hegstead, who died many, many, many years ago. And that procedure allows us to put something into a trust that was supposed to be in a trust, but was not put in the trust on accident. And so there's a case on it, and there are statutes that help us do a petition. Now, this workaround does not avoid any court proceeding. In other words, you see the word petition there, we still have to petition the court. But what we're asking the court there is to allow us not to have a full probate, and instead just to get a court order that instructs that this asset should be put in the trust, even after the death of the person who owned it. And so it's not cheap, but it's less expensive and less time consuming than a full probate. A small estate affidavit also works when there are accounts that are very low in value. Oftentimes people put their checking account, they leave that in their own name, and they've got their trust fully funded with everything else, but their checking account is in their name. And the value goes up and down. They pay their bills with it. They get income from assets and, that kick off income, and then they spend it down. And it never goes above 50,000 or something like that. We can get that transferred into the trust without a full probate, as long as it's a small value. And when I say small, I mean under 184,000. That's the statutory limit of all assets that could be held outside of a trust. So don't focus on the workarounds, focus on the title up there, failing to fully fund your trust. That needs to be avoided. Okay, we're moving on to the second half. We've gone through 1 through 5, and now 6 through 10. All equally important, no ranking here. They're all very important. But number 6 is making your own changes to your attorney-prepared estate plan. So this is the circumstance where clients do an estate plan and they spend all this money. And I saw this just recently. It was a will, and it was kind of an old will. And we found it in the drawer. We pulled it out. The person had died, and we flipped the page, and there was a photocopy of the will. There was an original will and a photocopy, and the photocopy had handwritten changes all over it, multiple pages, things crossed out, different percentages included. Ooh, what do you do there, right? Those handwritten changes were not signed. We don't know the signature. We don't know the handwriting of the decedent. We could probably find out, but think about all of the messiness that creates. Is this a valid change to the original will? Is it not? Are we sure that it was done by this person? Did they intend to make these changes, or were they just sort of thinking through changes, putting new numbers on there and saying, well, what if I gave my brother this amount and my sister that amount? But if it was never formally changed, then it's not valid. And it didn't go through the procedures of formally amending a will. But you can see how that might create the impression that the person intended to change. So now we could find ourselves in litigation, because now let's say you got brother and sister, and under the original version, it's 25-75, and the second version is 50-50. Well, if you've got an estate of a couple $1 million, then that difference in 25% going, swinging back the other direction is significant. And so people are willing to sue over that kind of a thing. So having a will that you've just now changed with a pen and just making some markings has now created more problems than it's solved. So wills should be, the answer to this is, if you have a will and you want to change it, it should be amended by a formal codicil, or just a whole new will that should be prepared by your attorney. The same thing is true of a trust. A trust has to be amended through a formal amendment procedure. And the amendment procedure is typically included in the trust instrument. It says this trust shall be amended this way. So if you try to amend it a different way, then it's not typically valid. Now, there are workarounds to that too, if it can be proved that it was the person's intent. But again, you don't want to go down that route, especially after you've died and now your family has to sort out these issues. Handwritten notes, just to sort of summarize, handwritten notes on original documents are not helpful. They invite litigation, confusion, questions, and problems. So do not write on your original documents. If your attorney prepared an estate plan and gave it to you and you've got it in a file, do not go and mark on it, even if you are convinced that you want this change to be made, because it's likely not going to be done correctly, and it's just going to create genuinely litigation. Okay, number 7, choosing the wrong executor and trustee. So there is no, quote, wrong executor and trustee. If you've chosen someone to serve and to administer your estate, then that's their job. But they're wrong if they're not quite suited for the job. And it turns out that they're going to spend more time, or they're going to make mistakes because they're not quite organized, or they don't really know how to do it. Then it could just be problematic. And so it's wrong in the sense that, well, you could have chosen a better one, and that would have been, less wrong or more right, if you want to put it that way. So I've listed a few considerations for choosing executors and trustees, but I first want to quickly mention the difference between the two. An executor is somebody who carries out the terms of a will. They're named in a will as the person that will be what is eventually called a personal representative once a probate is opened. So an executor just carries out the terms of a will. A trustee is named in a trust to carry out the terms of a trust. Both roles are what we call fiduciary roles. They both have fiduciary duties, but they are very different in the sense that a executor who then becomes appointed to serve in that role goes to court and carries out the terms of a will in a probate situation. If you have a will and you name somebody as the executor of your will, but you don't ever have a probate, that person is never really serving as your executor. You may also name that same person as the trustee of your trust, which in fact you should do. And that trustee would then carry out the terms of your trust, which does involve, stepping in, taking title to assets, handling payment of debts, and that sort of thing. So considerations for choosing who these people should be. Sometimes people want to involve family members. You might want to name one family member and they have full authority. In other words, a son or a daughter or a cousin, somebody who you're going to say, you are the one, you are in full authority. Other times you can say, well, I want one person to decide, but I want that person to have to speak with other people, but they still have the final decision. And that's a way to go. Name so-and-so as the trustee, executor, agent under your power of attorney, but that person has to consult with others. But they still have the full power, so if the other people disagree, that individual still has the decision-making authority. Very important that that be clearly spelled out. Generally, number 1 is preferred. Another option is bullet point number 3. You name 2 individuals and they serve together and they have to act unanimously. In other words, son and daughter, they are both co-trustees and co-executors. And so that can be useful if you really want the ballasting of one versus the other. Oh, my son's really good at this, my daughter's really good at that. Let's let them work together. And as long as you know they do get along and they're going to be able to work collaboratively and it's not going to create more delay or disagreement, then it's an okay choice. I generally prefer it to be one person, but having 2 is fine. More than 2 does become cumbersome in an administration. Your financial power of attorney selection, by the way, should mirror whoever you name for your executors and your trustees. And that way you don't have multiple people doing different things. So if you name son and daughter as trustees, they should be also your co-successor agents under the power of attorney. Healthcare directives are totally separate from this part of your estate plan. It doesn't have anything to do with the administration of your estate, but it has to do with end-of-life decisions. So it's important to choose those individuals carefully and choose somebody who can make a decision to pull the plug, give life-saving treatment, decide on disposition of remains, coordinate the payment of funeral arrangements, all those things. So your agent could be someone very different, and they're not going to be involved in the financial part of administering your estate. Okay, a few more left here. Mistake and misconception number 8. Failing to provide your trustee with instructions for what we call discretionary distributions. Discretionary distributions are when there's a distribution provision to a beneficiary, and that distribution is not clear as to what should be distributed and under what circumstances. For example, a trust, we're talking about a trust that would be set up, let's say, for example, after you pass away for the benefit of your children or for grandchildren. Let's say you have grandchildren and you want to put $100,000 into a trust for each of your 5 grandchildren. So you've got $500,000 in 5 separate trusts. That trustee, whoever's in charge of that trust, needs to have pretty clear instructions on what they can distribute for. Is this a trust that's really only for education? You don't want these funds to be used for anything other than to further their education. And let's say these trusts are going to stay in place until the grandkids turn 25 or 30 or 40 even, because sometimes your grandchild might go to college, finish up, do a career, then decide it's time for grad school. And maybe they go to grad school in their late 20s. And so having a trust like that, the trustee should have clear instructions on what those distributions are for. Do you want to provide distributions for the child when they just make a demand for it? I need money for rent. I need money for a car payment or for education. So is it discretionary? Is it fully discretionary, or is it restricted by what we call an ascertainable standard or any sort of standard? The standard we oftentimes use, a very common arrangement, is all net income can be distributed to the child, a grandchild or beneficiary, every quarter, every month, or every quarter, just frequently. And then principal distribution. So that would be like, okay, there's $100,000. It just generated 10,000 in income in the year. It's going to be distributed to the grandchild. But now the grandchild needs 25,000 more to pay tuition. So that's a principal distribution. And so should that be just for education? Should it be for whenever the child demands? Or grandchild? One approach that I like to see, and my clients tend to really appreciate, is setting up special instructions where we've covered the bases: income distributions, principal for health, they have a medical procedure, maintenance, support, they have to pay their rent, those kinds of things. That's all pretty straightforward. And then we say, if the grandchild or if the beneficiary has a special desire to start a business or open a business or purchase a business, the trustee can distribute, and sometimes we'll say 10%, 20%, 50% of the value of the cost to start that business or to purchase that business. So that kind of gives the beneficiary some incentive. Hey, I've got this trust here that will help me start this business that I've always wanted to start, but I have to come up with the other dollar funds to do so. Same thing with a home. It's very difficult for young people to buy homes these days, especially in Santa Barbara, but really anywhere. So a trust can be established that says the trustee is permitted to distribute X dollar amount or X percentage of the purchase price of a home. And we oftentimes balance that with, as long as the beneficiary can afford the mortgage and the distribution is not more than, say, 20%. In other words, it covers the down payment, and the beneficiary has to qualify for the payment of the rest of the amount. That way, the child or grandchild doesn't simply say, "Oh, I'm going to get a free house." No. Your down payment is covered, not the whole house, right? So that's a real neat way to incentivize beneficiaries. And I've used the example of a trust with $100,000 for grandchildren, but we oftentimes deal with trusts with many, many millions of dollars. And these are trusts for children and then grandchildren and then great-grandchildren. And so it's really good to include those kinds of very specific discretionary distribution provisions so that in the future, there's not a question about it. Okay, we're down to 2 left. Number 9, failing to review your estate plan periodically. Your estate plan is only as good as when you pass away, and it becomes irrevocable, as it reflects, again, remember that first slide, reflects your wishes and desires, is easily interpreted and understandable, and there's no vaguenesses, confusion, nothing that was mistaken. That's as good as the estate plan is. And as soon as your estate plan is prepared, it's interesting, I get this sense every time I do an estate plan with a client, the moment we sign it, that's when it is the most in tune with the client and their estate. It's the most perfect that it's ever going to be, right? From that point on, it is slowly, every day, it's like radioactive decay almost, if you will. It loses its efficacy because every day the value of your estate changes, the value of your investments change, your family situation changes, your grandnephew dies, your uncle leaves something to you and you inherit $100,000 or $1 million. So as soon as your estate plan is prepared and signed, every day after that, it's potentially losing its appropriateness to your situation. So you need to review it on a regular basis. And so the recommendation I give is that the time frame should be really just the default every 3 to 5 years. You should sit down, open your binder, or go through your estate plan documents and read it. They can be a bit cumbersome to actually read. So maybe you'll just look at the diagram or the summary, or flip to the pages that describe who gets what happens after the first death, what happens after the second death, who are the trustees that are going to handle, what are the provisions for successor trustees. So just do that every 3 to 5 years. Look at your healthcare directive as well. And once you see something, say, well, maybe it's time to go talk to the lawyer. Your lawyer is most likely, if you have one, not going to automatically review your estate plan for you every 3 to 5 years. You can maybe ask for them to do that, but they're not typically going to, on a repeating cycle, look at everybody's estate plan every 3 to 5 years. It's up to you to decide, hey, attorney, I would like you to review it and tell me if it still fits. Have there been changes that I need to address? That sort of thing. Other timeframes or things that might trigger. So maybe you just did your estate plan and then a year goes by and then there's been a change to the tax law. You might say, okay, I've heard in the news, I've been looking at the news, I've been reading the newspaper, and it looks like there's going to be a change to this rule that sounds important. If you hear the word estate tax, if you hear the word income tax or fiduciary tax, or if you hear the term basis, capital gain, that sort of thing, any property tax, if there's a change to the property tax law, like we had in California not too long ago, those changes should trigger in your mind the need to have a review of your estate plan, because any of those changes could potentially make your estate plan, which again was perfect the day you signed it, assuming it was, now completely inappropriate. I have clients who come in with estate plans that are 15, 20 years old, and my, oh my, how much the estate plan, the estate rules have changed. Tax law has changed. California tax has changed. Property tax has changed. There's a rule called portability that used to not be in existence. So much has changed that estate plan now, if somebody died, would lead to a whole bunch of consequences that could have been avoided. And so if you hear anything about there being a change to the tax law, call your attorney and say, hey, I heard about such and such. Does this affect my estate plan? And then that attorney should take a look and let you know. Other big things are, there's been a change to your financial situation. I did my estate plan. I owned a company at the time. 10 years later, I've now sold my company. I've retired. I've purchased another home. That's a big change. Those are some big changes. You need to call your attorney and say, do these changes affect my plan? Should I reconsider? Should we reconsider? Should there be a new trust structure? And that may cost you some money. The attorney may say, yes, I'll be happy to look at it. Send me your documents, send me the information about your financial change, and they'll review it and send you a summary. And that's going to trigger some cost. But by doing that now, you avoid the situation where you then pass away, and now this estate plan that was perfect in 2008 is now really inappropriate for your new estate. And I put in there the changes to your financial situation in either direction. I think of estate plans, as I said, the moment they're signed being perfect. And from that point, what the things that are changing are the value of their estate, the estate tax exemption and estate tax laws. So all these are changing concurrently. And you fast forward many, many years, what could have happened is their value of their estate could have gone down dramatically. They've gone into retirement, they've used up a lot of their retirement funds, and now they're in their 80s and their estate value is very different. It's much less than it used to be. Meanwhile, the exemption from estate tax has gone up. So now there's really not going to be any estate tax owed, and their plan that is designed around there being estate tax owed is not quite a good fit any longer. So if your financial situation goes up or down dramatically, that's a trigger for it's time to review your estate plan. Another one that happens quite often that is personal to you is your family situation. You have somebody who is a key part of your estate plan and they pass away, or they begin to develop dementia, or they have their own busyness. Oftentimes it's a child. My son, he's named as my trustee, but he just had his wife just had twins, and he just became this president of his company. There's no way he's gonna be able to handle this right now, right? 20 years from now, it might be different, but right now, maybe you should change it and take him out as trustee and put somebody else in. Death of family members, any change to your family situation. I'll give one more example because we have a little bit of time before we get to my last one. Another situation that oftentimes arises is one of your beneficiaries becomes, or it appears they may develop an incapacity. Something like it could be a grandchild is born with an intellectual disability, or maybe it's a grandson who likes to ride motorcycles and he's had an accident. I chuckle, but it happens, unfortunately. And they're not fully incapacitated, but they're just not ever going to be fully independent because of that accident. I had that happen not too long ago. A client whose son was in a motorcycle accident. And before that, he was just a fully functioning normal individual. And after that, he was not. And so the plan needed to change dramatically to have a new plan for that individual. So any change to your family situation that appears to affect finances or where things should go when you die, those kinds of changes should trigger your review of your estate plan. Last mistake and misconception, at least the last of the top 10, and there are 11 through many more after that, but these are the top 10. Failing to coordinate with your retirement accounts with your trust, the beneficiaries of your retirement accounts with the beneficiaries of your trust. And here's what I mean by that. The beneficiaries of IRAs or 401ks, retirement plans, even life insurance policies, annuities, those pass to those beneficiaries by filling out the name of a beneficiary on a beneficiary designation form. Those need to be filled out, obviously, before you pass away. Typically, people name their spouse as their primary, and then they name the children as contingent or secondary beneficiaries in case both spouses die at the same time, or wife dies and husband fails to update his beneficiary designation, and then he later dies. Now he's got contingent beneficiaries, and those would be the children. The reason I say this is a mistake or misconception is that sometimes clients name their trust as a beneficiary of an IRA or a retirement account, or sometimes they name a primary beneficiary, but they don't name a contingent or a secondary beneficiary. In that circumstance, oftentimes what happens is the IRA custodian will have a default provision that essentially states that that IRA goes to the estate of the individual. That means probate. If you have a estate named as a beneficiary of an IRA, that means it goes to the probate. If you name the trust, this is the second hash mark there, a trust should not typically be named as beneficiary of an IRA. But if you do name a trust as a beneficiary of an IRA, then a whole host of other consequences could descend if that trust is not designed to hold that IRA and to qualify as a designated beneficiary so that it can either be an accumulation type trust or what we call a conduit trust or some other arrangement. So you have to coordinate what to do with your retirement accounts with the structure of your trust and who the beneficiaries of your trust are. So two last bullet points on this is that if you want to give to charity, it is more efficient oftentimes to give to charity upon your death through your IRA or even during your life with qualified distributions. Name a charity as a beneficiary of your IRA versus naming an individual as a beneficiary of an IRA and then giving cash from your trust to those charities. So you have to coordinate all those and talk to your attorney about what's the most efficient way to give to the charities and make sure my heirs get what I want them to get in the right structure for them to get it. So that's the last bullet point. Clients should think through the overall plan. Who's getting what? And where are they getting those assets from? Do I want my son and daughter to get the IRA and have required distributions over 10 years? But then they get the trust outright, or do I want something different? So coordinate all of those assets together, because oftentimes your IRA is one of the biggest assets in your estate, and it doesn't go through your trust. It shouldn't typically. And think about what is going through your trust, like your house and your other investments. So you just want to make sure all of your objectives are being met. So having just finished the 10th mistake or misconception, we've reached the end of our presentation. Of course, I've already seen a few chat messages and there are some questions I can imagine. And so we're going to open it up a little bit here. I think Andrea is going to give us some questions that were in the, that have been presented, and I'll see if I can answer those.
Thank you, Brett, so much. We greatly appreciate you sharing your expertise with us and your time. One of the first questions in the chat is pretty much what you just covered in 10, but I thought I would reread it so you could restate a few things to make sure everyone feels comfortable in your answer. If beneficiary forms are in place, such as with investment accounts or life insurance policies, is it necessary to move the accounts/policies into a trust?
Yes and no. And I'll split the answer between two different kinds of assets: life insurance policies and investment accounts. And these are very separate from IRAs, right? A brokerage account that is non-IRA, just a regular brokerage account that you invested funds in. Vanguard, Fidelity, Charles Schwab. Oftentimes those companies will allow you to fill in a beneficiary designation form for that account, even though it's not an IRA. And so upon death, that entire account goes to those beneficiaries. In my view, and other attorneys may disagree, but in my view, that's not the best way to plan your estate. And the reason is because that investment account, upon your death, goes directly to your children or to whomever you've named. It does not go through the trust, as I think it should, because the trust is the thing that you've designed to administer your entire estate. Let me add some sort of meat to that. Your trust is going to be the conduit for the payment of any final debts, the payment of estate taxes if there are any estate taxes owed. Let's say there's a reassessment on the home that has to be paid while the home is being sold. Let's say there are other expenses that the trustee is going to incur to administer your trust. If most of your assets, or even a large chunk, pass automatically to your kids, then that trustee is now going to be hamstrung in some way, or could be, in administering your trust appropriately. So you want your trust to be the conduit for the administration of your entire estate, especially if there's any differences in beneficiaries. For example, I want one child is going to inherit the home because she's always wanted to live here in Santa Barbara. The other child is not. And so we're going to say the house goes to so-and-so, and then the brokerage account passes automatically. Well, now you have a situation where the trust could have no funds out of which to pay any expenses it may have to pay, because those accounts that pass automatically. That's just not a good result in my view. So the trust should not, those investment accounts should not name beneficiaries directly. The trust should hold that account. Life insurance is a little different. Life insurance policies, it's, in my view, appropriate to name beneficiaries, and it does not need to be titled on the trust unless it's what's called an irrevocable life insurance trust. But I don't think that's what the question was about.
So let's kind of go from some of the first things you spoke about. When is it okay or appropriate to just have a will and not a trust?
It's appropriate to just have a will where the assets that the individual owns upon death are under the threshold value of $184,000, and that excludes assets that pass automatically. For example, if an individual has an IRA that has $500,000 in it, and they name, let's say they're single, and they name their neighbor or their friend or whomever as the beneficiary of that IRA, that's going to happen automatically, and that's not going to trigger a probate. Let's say the other thing they have is a checking account with $15,000 in it and some items in their apartment, that, tangible personal property. That's a fine situation for the will to say, I give all my accounts to so-and-so, and I give all my tangible personal property to so-and-so. And that can all happen outside of a probate. It's not the best, but it does avoid a trust and setting up a trust, which is much more expensive. But the reason that works is because if the total value of what's governed by that will is under the 184,000, again, disregarding the IRA because that passes automatically, then it's okay to do it that way. The only problem is if there are expenses or debts that have to be paid, now that will has to be probated in order for those creditors to get paid. And so it may put us into a probate anyway. So again, it's a very context specific answer, but those are the kinds of situations. Low value, and not a lot of assets, and under the $184,000 threshold.
Okay, thank you. I have a number of questions about how do I put my home, personal property, and bank accounts in my trust? There's another question, if bank accounts with checking and savings are not in the trust name or just personal name, but have beneficiaries, is it okay, or should all bank accounts be in the name of the trust? So if you can kind of talk through home, personal property, and bank accounts in your trust, that would be great.
We'll start with the home or any real property. Real property is titled in a trust by recording a deed in the county recorder's office where that property is located, be it in California or another state. And that deed says from John Doe to John Doe, trustee of the John Doe 2025 Revocable Trust. That deed gets prepared by the attorney typically and then recorded in that county recorder's office. And at that point, it's now a trust asset. So that's how you make sure real property is put into a trust. Things like accounts, checking accounts, savings accounts, they don't all have to be in the trust. Again, if the threshold is very low of the value of the ones that are outside the trust, what I see almost every single post-death administration is that invariably clients have named one or two of their children as beneficiaries of an account, or they actually put them on the account. Let's say it's dad and he's the surviving spouse and his wife is dead and he's got three children and one daughter is nearby. And so he says, well, you live nearby. I'm going to name you as a joint owner on that account. And then when he dies, it automatically transfers to that one daughter. Well, if that account is $20,000, $30,000, $40,000, that account does not get split among the other kids. It goes to that one daughter, and she has no duty to give it to the others. In fact, by him putting her name on it, in a sense, that was a gift of that account to her. So that can create tension because now the other daughters say, well, I thought this was dad's money. And it's like, well, it was, but he gave it to me. And it's like, it's up to that daughter to say, okay, he gave it to me, but I'm going to share it with you. And it just creates that tension. So I don't like for clients to put their children or other people on the account as an owner during lifetime, like as a joint owner. And if you name them as beneficiaries on the account, well, then it can skew the balance. Let's say you have a trust and it holds assets, and then upon death, everything goes equally to kids. But then this one account, you've named your son as the beneficiary on it. Well, he's going to get that 20 grand off the top. And then 1/3 of the rest of it. So it just can create an imbalance. So those are just things to think about. There's nothing inherently wrong with that if that's what you want. It's just those things need to be thought through.
Thank you. I think you've kind of answered this, but I'm going to read this question anyway. Having a beneficiary form does not avoid probate. That's the question.
Having a beneficiary form does not avoid probate. So that's a question.
That's a question. I think it does avoid probate because you're designating a beneficiary for an IRA or whatever the beneficiary form is.
Naming a beneficiary on a retirement account does avoid that account having to go through probate.
Yes.
If the person dies and all they own no real property, they own no tangible personal property, not even the clothes on their back, so to speak. All they have is an IRA, and it's got $100 million in it. And you name beneficiaries on that IRA, and you have no trust and no will. You have no probate.
Yeah. This next question kind of ties in with a question you and I had thought about in
Hold on
advance.
1 second.
Oh, sorry.
Assuming your beneficiaries, I could hear attorneys in the chat. Wait a second, no, I'm sending an email. As long as your beneficiaries survive you. Okay, next question.
Next question. Please review benefits drawbacks of generation skipping trusts and also define what defines a successor trustee. And you and I had also talked about this. If someone doesn't have anyone who they want to carry out their advanced healthcare directive or serve as their successor trustee, what should someone do and who is there that could potentially help them?
Sure. If you don't have anybody in your family who is a great fit to be trustee or in any capacity at all, any fiduciary capacity. There are great individuals in town who will serve in that capacity, trust companies in town, professional fiduciaries. I could provide a list of 5 or so people in town who are trained to do this, and they'll meet with you and get to know you and be happy to named as your successor trustee or your executor or your agent under power of attorney. And so having a successor, all that means is during your lifetime, you are the trustee of your own trust. And so the successor is the person who steps in after you, either because you've become incapacitated or because you've died. So that's what successor trustee means. It's just the person named after. Sometimes you can name someone and give them the power to name a successor. I do this with my clients often. If the client doesn't have anyone, in fact, I was drafting something like that this morning, the trust document will say, the successor trustee shall be named by the attorney who's representing the estate, or by Mullen Henzell, my firm, somebody here. Those are options, and they at least give you the option to avoid having to go to court. If you don't have a successor trustee named and there's no mechanism to name a successor trustee in the trust instrument, you have to file a petition with the court to have one named. There was another part of that question that I think I missed. What was the other part?
Generation skipping trusts, the drawbacks or benefits.
It's 12:56, 4 minutes for GST. Benefits, drawbacks. Benefits are that you can avoid repeated tax at every generation when you have a generation skipping trust, that is a trust that is exempt from the generation skipping transfer tax. Now, how a trust becomes exempt is another whole lunch and learn, or maybe even more. But the benefit is that at every successive generation, you don't have a new tax applied because those assets are not considered as part of that generation's estate. For example, you set up a GST trust and it exists for the rest of your children's lifetime. And then your children's children, so your grandchildren, that's what we call a generation skipping. I mean, that's a skip generation. And those grandchildren get the benefit of the trust. And let's say the trust has $50 million in it, and they just get some income and principal distributions. And then upon their death, it goes to their children, your great-grandchildren. Those, every generation does not have a new trust, a new set of taxes applied, another set of estate tax. It's not included in their estate for estate tax purposes. So it's a great benefit. The downside is cost of administration, complexity, cost even to establish. They're more expensive to draft. But for high net worth or people with the desire to pass on millions of dollars every generation, they're great. They don't make a lot of sense when you are talking about less than a good number of millions of dollars. It's a 5, 10, 15, in that range. That's when it starts making sense to do a GST trust. Under that, it doesn't really make a lot of sense.
Okay. So we have a couple minutes left. I have a question. Do you recommend transfer on death for checking or savings accounts?
I do not. For the reason articulated before, transfer on death accounts, they avoid the trust, but by avoiding the trust, they then hamstring the trustee and give those funds to that person. And even if that person is the trustee, let's say you have one son and 2 daughters, and you name your son as the trustee and you've named him as the beneficiary on that account. Well, he's going to get that account upon your death, and he doesn't have to use those funds for the trust administration. It's a gift from you to him. Meanwhile, the daughters are going to get a share of the trust, but they're not going to get that account. So I don't recommend it. Now, you might say, well, I could just name them all as transfer on death beneficiaries, but then what if one of them dies before you and you never update the transfer on death? It's just best to put it in the trust.
Kind of a different question that we've talked about briefly. What do I do with my digital assets like my email and Facebook account?
Yeah, your will and your trust should address that. You don't put those assets into trusts during lifetime, but your power of attorney for financial matters and your will and your trust should say, upon your death, these folks are empowered with the ability to take possession and control of the asset, to close the accounts down. Let's say, for example, it's Facebook or it's an email account. They should have the power to get control of those and then delete things or save them onto a hard drive, that kind of thing. Or if it's a OneDrive or a cloud account, you need to have instructions in your will, your power of attorney, and your trust so that those fiduciaries can then carry things out. If you don't put that in there, then the default is it just goes pursuant to the terms of the contract you've signed when you clicked the little box when you opened your Facebook account or created your Outlook account or Gmail.
Well, thank you, Brett. We really appreciate your time and expertise. Here are our contact information if you have any additional questions for me or for Brett. And as you consider your estate plan, I hope you might consider adding the museum. I'm available to help with any legacy giving questions you might have about how to make that possible. Also on the screen, you'll see our upcoming events. We have 2 more Lunch and Learns, May 13th and September 9th. We also, in November, will be hosting our free Estate Planning Essentials workshop. The workshop will be from 2 to 4, and there will be a reception with estate planning professionals from 4 to 5. And I'm thrilled to say that Brett will also be a key featured speaker at that afternoon workshop. So we hope you will join us. Thank you again, Brett, and thank you to the museum's Planned Giving Advisory Council for helping to coordinate the presentation. And thank you to all of you who attended. Have a great day.